The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain emergency guardianship. So let's first talk about guardianship generally. Guardianship is when one person is given by the court decision-making authority for another person's financial or health or personal decisions. This is usually happens in the case of either a minor child or a disabled adult who is incapable of making certain decisions for him or herself. A guardianship is initiated by someone filing a petition for guardianship, and then there's usually a hearing on the merits of whether a guardianship is necessary and whether the petitioner or the person suggested in the petition is the appropriate person to be the guardian. Sometimes the disabled adult will object to having a guardian appointed, and in that case, evidence is put on, witnesses, usually expert witnesses, medical experts or psychological experts, and sometimes lay witnesses, friends and family of the person that can testify as to the necessity of the guardianship. The problem is that this can often take a couple months between the time that the petition is filed and notice is given to the disabled adult and the time that a final hearing on the merits of the case is held and a final order can be entered, either denying the petition for guardianship or appointing someone to be the disabled adult's guardian. So what happens during that couple months span? This is where emergency guardianship comes into play. An emergency guardianship or a temporary guardianship is meant to cover the gap between the time that the petition for guardianship is filed and the time that the final order is entered appointing a guardian. It's really only used if there is an imminent threat of harm to the disabled adult or his or her estate, and during the period before the guardianship can be entered, and there's no other reasonable alternatives, because this is going to be entered before there's a final hearing on the merits, and sometimes before notice is even given to the disabled adult. So there's kind of two different types here. There's one where it's entered immediately without notice even being given, and a different type where notice is given and there's a hearing on whether a temporary guardianship should be entered, but there's not the final hearing with the presentation of witnesses and evidence. And they're both kind of lumped together as an emergency guardianship. It's really just the nature of the emergency. If you want to have an emergency guardianship entered without notice, you have to show that the time period it would take to give notice of a hearing on the petition for emergency guardianship would do harm to the disabled adult's estate and that there's no other alternatives. So these are typically only valid for 30 to 60 days or until a final order has been entered. And if it takes longer than 30 or 60 days for a final order to be entered, it will typically have to be, the temporary guardianship will typically have to be renewed by the court. And it's typically used to protect from any imminent abuse, neglect, or financial exploitation against the disabled adult. And really, to kind of sum up, you have to show that there's a real danger between the time from that the petition for guardianship is entered to the time that a final order can be entered, that the disabled adult will be either physically harmed or that his or her estate will be harmed by the lack of a temporary guardian, and the bar is pretty high here, and that there's no other alternatives other than temporary guardianship to prevent this harm. And if you can do that, then you don't have to have a full hearing on the merits to have this temporary guardianship entered, and sometimes you don't even have to give notice to the disabled adult and other interested parties. But the less notice you're going to give, the higher the bar that you have to clear from an evidentiary standpoint to show the court that this is important and required and the only reasonable alternative. So if you have any questions, you can leave them below the post at learn-about-law.com or below our YouTube video on our YouTube station. We try to answer within a couple days if we can, although we don't give specific answers to specific legal questions about your case. If you need help with that, you can give us a call at 630-324-6666. That's 630-324-6666 to schedule a free consultation. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. If you found this helpful and would like to be updated when we post new content that is interesting to you, please subscribe to us on YouTube, iTunes, and SoundCloud, and we try to put out an article and video every business day. Thank you so much for listening. We hope you found this helpful.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.